what do you suppose Luigi Mangione is pondering in his jail cell right now? You and I are here having a gay old time, right? You're watching TV, I'm doing the work thing. He's in the cell after his first day in court. I have an idea what he's thinking, and it might have to do with the following questions. When is a smoking gun not a smoking gun? When is an anti-insurance manifesto not an anti-insurance manifesto? And the answer, of course, is when they're ruled inadmissible at trial, off limits as prosecution evidence. If a jury doesn't see them, they might as well not exist, right? That is the exact reason that Luigi Mangione will be spending much of this week in a New York City courtroom, almost exactly 1 year after he allegedly gunned down United Healthcare CEO Brian Thompson on a Manhattan sidewalk. The actual anniversary is this Thursday, and I'm going to get to just how well his arguments went down in court today, but first things first. Luigi walked into the courtroom today in shackles, but the judge let him swap out his jailhouse jumpsuit for some pretty nice threads. Here's the actual wardrobe note that spells out exactly what he's allowed to wear all this week during his case. 2 suits, 2 shirts, 3 sweaters, 3 pairs of pants, 5 pairs of socks, and 1 pair of shoes. No laces. Can't have the laces. Still an inmate, fella, no matter what you wear in court. And for the hearing itself, he is allowed to lose the hardware, meaning he can sit in court unshackled. I should also note that this is state court, where Luigi faces 9 charges, including murder. But he's also facing that federal charge, a murder charge, right, for the very same crime. And the feds are seeking death in that case. The state trial will likely come first, and Luigi's backpack, which was brimming with smoking guns, almost literally, will either have a starring role in the case or it won't come up at all. And that, my friends, is Luigi is pondering in his cell tonight. He certainly hopes that no one is ever going to hear a mention of it, aside from you and I talking about it right now. But I don't know, you might not be on the jury, so it won't matter for you. But the 12 people who will be impaneled in his case, 24 if you think of 2 cases, it's going to matter to them. Luigi had his backpack with him at this here McDonald's restaurant when he was spotted and arrested in Altoona, Pennsylvania. That was 5 days after the shooting. The local cops searched his backpack right there and then in that restaurant. And they must have thought they hit the jackpot because they found, among other things, a 3D printed handgun that prosecutors say matches the weapon, the murder weapon. They also found a notebook filled with handwritten complaints about for-profit healthcare, including a plan to, quote, whack a health insurance executive at an annual conference. Yeah, smoking guns. What the police did not lay their hands on that day was a search warrant, which, let's be clear, is not always necessary, right? It's not always a must when somebody's arrested, you know, to have a search warrant to go through their bag or their backpack or their car, right? But Team Luigi claims the circumstances in Altoona, those were different. It was required. And without a warrant, nothing on Luigi's person can be used against him. My first guest was in court for day 1 of what amounts to a mini trial. Erik Uebelacker is the New York City courts reporter for Courthouse News. Erik, first and foremost, the reaction when, I'm always curious about when Luigi walks into a court hearing, and I don't say that for the prurience of it. I say it because he's amassed a following of millions of fans. Some of them show up in person to be there in the courtroom to lay eyes on him in person. So what was the reaction when he walked in wearing a suit for the first time?
Well, let's be clear, the people that made it to court today in support of him were likely very, very tired. There were camps, tents set up outside of the courthouse for pretty much the entire Thanksgiving weekend for people hoping and praying to get inside. Court officers did a very nice job of not letting the spectacle of this case interfere with the proceedings of the day. There was no audible gasp or anything when he walked in. There really hasn't been in any of the appearances that I've been at. But it was a little bit different. He didn't walk up the center of the aisle of the courtroom as he normally does. He came out from the holding cell in the back, so there was kind of even less of an opportunity. But as you noted, it was the first time we've seen him in this particular getup. He was not shackled for the entirety of the court hearing. And, you know, he used his hands throughout the hearing. He took copious notes, pages of notes from what I saw, and was pretty intently watching a lot of the evidence on the screen.
So, Erik, I'm not going to lie, I watch a lot of court proceedings. I didn't expect a 5-day hearing on suppression of evidence. It's really, really long. You know, for those of us in the business, maybe a day or two, but for 5 whole days, is it too early to score on day one?
I think it is, especially because we're looking at it at least 5 days, I would guess. We're expecting maybe around 30 witnesses in total, including a couple of defense witnesses sprinkled in there. Today we got to just 5 after kind of a late start for some technical difficulties. So, yeah, it's still very, very early. The judge has made no rulings. It's important to note that these kinds of hearings are pretty much all a net gain for the defense. You know, any evidence that they could get suppressed, even if it's not much at all or none at all, it's more than they had suppressed, you know, last week or the week before. So this is all for the benefit of the defendant, Luigi, in this case. And even if they get no evidence suppressed whatsoever, some of the defense lawyers that I talked to noted just how important this is to kind of plan. They can see how some of these prospective witnesses are going to testify at trial. They have the opportunity to cross-examine them first before they have to sit in front of a jury. So there's a lot that they can learn even without this the whole suppression aspect here.
It's like a poker game, I like to say, and they get to see the hand of the opposing player and plan accordingly. And that is like money for defense attorneys, right? Because otherwise you're tap dancing live during trial, wondering what's the prosecution going to come at me. Look, I know that they get discovery, but it's not the same as strategy. So strategy is always super critical. Okay, I want to talk a little bit about something else that's not getting as many headlines, and that is the gun in the backpack and the manifesto are all really big. But there's all these statements that Luigi apparently was making. For lack of a better description, it kind of sounds like he was singing like a canary when he was in his holding cells in Altoona, well, in Pennsylvania, but also I think when he got to New York possibly too. And there were guards that were assigned to watch him like a hawk. I think the one expression was, "We don't want an Epstein-style situation." Meaning, wow, we don't want this high-profile guy to take his life, so he's going to be watched by somebody, you know, nonstop. And the somebodies were guards who were up on the stand today saying, yeah, that guy liked to talk, and he talked a lot. What did he talk about?
Well, that was definitely the most interesting part of today was the testimony from the 2 corrections guards who kept constant watch over him because, as you said, he's a high-profile defendant, and as one of the guards said, we don't want an Epstein-like situation happening. Pretty shocking thing to hear in open court in a case like this. But the first guard, the one who made that comment, he's an ex-British combat veteran. I believe he was in the British infantry. He seemed to kind of genuinely enjoy talking to Luigi last December, just for the 10 days that he was locked up in Pennsylvania before he was extradited. You know, he said that they talked about things like travel, like literature, even talked about healthcare at one point. He said he didn't remember specifically Luigi saying anything one way or the other about healthcare, but he said that he offered his own opinion. Now, when the defense pressed him, the corrections officer, for his own opinion today, he said he couldn't recall it, so didn't get much out of that. But yeah, I mean, he made it out to seem like, you know, Luigi was here in this cell all day, every day. He was separated probably 2-3 feet from the guard between the plexiglass wall that he was behind, and they talked for a majority of the day. The second corrections officer seems like he was agitated to be in court, which were his direct words. He answered one-word answers all day, said he had no interest in talking to Luigi, and that everything that Luigi told him was just off the cuff. He didn't ask him anything. We'll see what the judge thinks about that and whether or not he'll take that as admissible. But it's a very key issue for the defense because the defense is trying to argue that, you know, these officers in one way or another coerced information out of him that was could be used against him in these cases. And the guards are saying, no, he gave this to me voluntarily.
Yeah, that's critical, right? Because Miranda goes so far, right? You could be Mirandized, but if you decide to sing like a canary later, you don't get the benefit of protection from that. You got to shut your cake hole. I mean, that's the whole, you have the right to remain silent. Mostly lawyers will say, I urge you to exercise it. Erik Uebelacker, always great to talk to you. Thank you so much. We're going to probably tap you a few times because you really are an eagle eye when it comes to these proceedings. Thank you for this.
Thank you so much.
All right, so could Luigi's backpack actually be tossed from the case and the contents therein? Is there even a case without it, both state and the feds? if that backpack goes away. I'm joined now by defense attorney and former prosecutor and friend of the show, Mark Eiglarsh. I'm going to just put it to you. I mean, if the backpack goes away and the gun goes away and the manifesto goes away, Mark, do they have a case?
Yes, they do. They have a video, and with that, they have statements that they will likely be able to get into evidence. And let me have everybody just take a deep breath. The defense lawyers are doing what defense lawyers do to ensure due process. It doesn't mean that they actually have a legitimate claim to get this stuff suppressed. I'm predicting now that the judge is going to allow all the contents of the backpack to come in. The judge is going to allow those statements to come into evidence, and understand that the defense is merely ensuring that if he is convicted, there won't be an argument that they rendered ineffective assistance of counsel, meaning they did their job. They challenged the evidence.
5 days worth of it, too. That's pretty effective, if you ask me. Okay, I love police shows. I watch On Patrol Live every weekend. I sometimes fill in as a host. And if there's one scene that I see repeated over and over in the field, it's police officers making a stop, detaining someone, putting said someone in cuffs, and searching their purse, backpack, and if the dog alerts, the car. But let's stay away from the car for a minute and just talk about the purses and the backpacks and the pockets. Sometimes it's for the officer's safety, and others, it's sometimes for an inventory search to make sure that that detainee gets all of his or her stuff back. So how all of a sudden are these lawyers saying, oh, you can't do that. You can't search his backpack in the McDonald's?
The lawyers are saying that because that's their job. That's the same thing I would argue. It doesn't mean that they actually believe this will prevail. They just say it passionately, and it makes for a great soundbite. I don't see a judge or an appellate court ultimately, when this is reviewed, saying that officers can be around someone's backpack, have no idea whether there's a bomb in there, and be able to sit back and say, you know what, that pesky Fourth Amendment, our forefathers fought and gave up their lives, so I won't be able to look inside to ensure my safety is okay. Garbage. They're going to allow that to happen all day long. And ultimately, even if the court finds that they should not have gone into that backpack, there's something called inevitable discovery. Eventually, they would have realized who this was, placed them under arrest, and then pursuant to arrest, they would have been able to search and inventory what's inside the backpack.
So what I'm gathering from you is that this is all adorable. They're not going to prevail. That gun, that 3D printed gun, which is literally the smoking gun, if you believe the prosecutors, it matches the murder weapon. And the manifesto that talks about going to that conference, trailing his schedule, talking about United Healthcare, and that specific morning. I mean, it is just, it's almost like the blueprint that why Mangione was carrying it around with him, I will never understand. But you think that there's just, this is all just going to be an adorable thing in the rearview mirror.
I wasn't going to correct you when you said adorable once, but you said it twice. I don't agree that anything's adorable about this. I don't love that word. I will tell you, though, that you can't entertain a plea offer with a client like this, I've been there, until he knows what type of evidence will be used against him. And until you challenge the evidence, you don't know what the case is. Once all these defense motions are denied, and then his attorneys have a come-to-Jesus discussion with him, like, hey, dude, we're likely not going to win this case. And, oh, and by the way, you may get the death penalty in the federal arena. Maybe it's best if we kind of work all this out and you get life, which is what you deserve anyway.
Yeah, I hear you, and I feel the same way. I was just surprised at 5 full days of the court to go over these suppression hearings.
That's justice.
Like
that's due process. That's okay.
Yeah.
No,
Effective.
It's okay. It's due process.
Effective.
It's the Constitution working. Effective. There you go. It's not adorable, though. It's not adorable. No.
But you're adorable, and I always appreciate you coming on. Thank you so much, Mark. I'll see you soon.
Oh, thank you very much. Thank you.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.